I mean, I count the things that I'm willing to risk my life over. I can count it on one hand. Bag of chips isn't on one of them. We are the armed attorneys. Today, we're talking about a case of some alleged thieves who subsequently claim self defense. Now, this is an important topic because we see society breaking down around us, and whether that is something that would be justified, that's kind of what we're going to be going through today. But before we begin, show your support for the Second Amendment by hitting that like button. And Edwin, can you give us a rundown of what we're talking about?
Yeah, we actually hear hypotheticals like this all the time.
Yeah.
People are always calling up with these weird hypotheticals. And this is kind of an example of how things can actually happen in real life. And it involves multiple issues about, who was right and who was wrong, who's justified and who's unjustified. So it started with just a common everyday incident of shoplifting. So there were two Utes at the convenience
They're
store.
teens, they're 17 and 18, adults under Texas law.
Yes. And they clearly shoplifted a bag of chips. Maybe there was something else, but it was clearly low value items. Well, the clerk, as is his right to do, saw them, and he didn't try to stop them while they were in the store, but he did follow them out of the store, yelled at them about stealing the chips. They subsequently yelled at him about stealing the chips, but then they began to walk away and they began walking down the street. Well, he gets in his car and he follows them. So he gets in his car, he follows them, seen missing. He winds up shot and killed on the side of an interstate feeder road in his vehicle. So the story from the police is that he followed them. The teens then pulled their guns and shot him while he was in the vehicle. The story from the teens, who have now turned themselves in, is that they acted in self-defense in that he followed them. He pulled a gun on them. They never say that he shot at them. They say he pulled a gun on them. They then pulled their guns. Now, were they in lawful possession of these firearms? Well, they pulled their guns and they shot him and he died. So that's what we do know, is that they did steal these chips. The clerk did confront them. The clerk did follow them. Like I said, seen missing, clerk winds up dead on the side of the road. So was this self-defense, or was this just simply an act of defending property, which you're allowed to do under Texas law, that suddenly went horribly, horribly wrong?
Yeah, so it raises a couple of interesting issues of, was clerk justified? Would the alleged shooters in this case, would they have been justified under the circumstances? Let's kind of take it apart piece by piece. The first one would be, let's say clerk hypothetically did have a gun, because that's what the teens are claiming at this point. Would he have been justified in, I don't think anyone is claiming that he shot his gun.
It has not come out yet, and I don't think it will. I think that the teens are relying on the fact that they just simply said he had a gun. They never said that he actually shot the gun. So I think the most we can assume is that he brandished it at them while he was following them in his automobile.
So let's go through those two different hypotheticals. First, just displaying, and then I imagine that their story is probably going to change and say that he discharged a firearm. But let's go with the first hypothetical of him just displaying a gun. We have to talk about whether or not that would be justified under the law.
Well, under Texas law, you are allowed to defend property with force, and in some circumstances, with deadly force. This is a circumstance where clearly the clerk would have only been allowed to use force because it was a theft, it was not a robbery, and it occurred during the daytime.
So when we say force, think punch, grab, tackle, restrain, something that might hurt, leave a mark, but wouldn't cause serious bodily injury or death. Now, Texas has a provision of our law where we say the production of a weapon or a production of a weapon or otherwise constitutes a use of force so long as it's done as a warning. And so not discharging the gun, not using the gun, just displaying the gun would be constitute a use of force. So under this circumstance, would that be justified?
I believe so, because it is a use of force, and Texas does have this very unique provision which says that you can produce a gun, you can produce a weapon, including a firearm, if it is done. If it is done, cause apprehension, and it is specifically defined in the statute as a use of force, not deadly force.
And so if we're responding to theft, we could use force. Production of a weapon under these circumstances justified. Could then the, alleged murderers at this time, I mean, couldn't they claim self-defense?
Well, that's one of the unusual kind of situations is, do you actually have to wait, which in many cases would be too late, for them to actually discharge the weapon and then escalate it to use of deadly force?
Right. So and let's say, because I imagine that they're going to say, oh, well, he shot at us. If clerk went out stopping a theft, he'd be justified in using force. If he jumped straight to deadly force, would that be justified?
Well, if he jumps straight to deadly force, you have to look at whether or not they are going to be disqualified from asserting self defense under Texas law, which would include the fact that, were they in the commission of a crime? We know that they had committed a crime. What if they were unlawfully carrying that weapon? Wouldn't that be a crime?
Yeah, one of the alleged perpetrators, 17 years old, they wouldn't be. There isn't a scenario where they could be lawfully carrying in public, and so if that was the shooter, then we can safely say they were unlawfully carrying.
Uh, yes. And would that crime be enough to disqualify them?
Probably not.
Okay.
It'd impose a legal duty to retreat. Maybe it might mess with their self defense claim. They might lose legal presumptions of reasonableness. But just because you're breaking the law, if you find yourself in a self defense scenario, the situation that comes up frequently is, let's say somebody's trespassing. Movie theater has a no gun sign. You disregard it. You go in there. Shooter comes in. Do you have to sit there and die? No, obviously you get to defend yourself, but does it mess with your self defense rights? Are at trial? Maybe it does.
Now, what about the issue of provocation?
I don't think that there's a provocation issue here.
Well, Texas has a very specific definition of provocation.
Yeah.
I know that the word provoked gets thrown around a lot.
Yeah, most
You
people
provoked me.
Yeah, most people just think about it as you started the fight.
Right. But specifically under Texas law, Texas self-defense law, provocation means that you have to act in a manner that basically you're doing it in an effort to goad the person into using force or deadly force against you as a pretext so that you can use then deadly force against them.
Yeah, and then the last thing that I think comes up is, because we have these kind of three elements when a use of force or use of deadly force is justified, reasonable, immediately necessary. And then what are you responding to? Unlawful force or unlawful deadly force. And we have some case law now that says, it's not a factual determination by a court to determine whether they were, responding to unlawful force or unlawful deadly force. In this case, that would be the store clerk. Was the store clerk's use of force or deadly force, was it unlawful? They actually look at the mind of the self-defender at the time that they act in self-defense, and what did they think? Do they think it's lawful or not? And that throws a monkey wrench in the whole situation.
Oh, yeah, because one of the tenets of self defense law is that the jury will be instructed to look at the circumstance from the point of view of the person who used deadly force, the defendant.
Yeah, and we have kind of a previous discussion on that. We'll link that in the description below about a hunter who was confronted by an alleged landowner and who would have been justified had, a use of force scenario broken out. This is kind of similar, except, based on the facts that we know right now, it does not seem like their self defense claim is going to hold water.
This is certainly a tragic situation, probably shouldn't happen. And, should the clerk have followed him down in his automobile?
I mean, I count the things that I'm willing to risk my life over. I can count it on one hand. Bag of chips isn't on one of them. But that's a tremendous tragedy. But I don't think thieves should be getting the benefit of the doubt in situations like this. And I can't imagine a jury is going to go along with it.
Oh, no. And believe me, there's nobody more anti thief than me.
Yeah.
That's one of the things that I pride myself on.
Edwin doesn't take thief clients.
I honestly don't. In my career, I've very rarely taken thief clients. They just seem like morally corrupt individuals.
Plus, you like your stuff.
I do love my stuff. So this case, if it goes to trial, it's going to be extremely interesting to see how it turns out. If these individuals are convicted and this case is appealed, it will certainly give an opportunity for the appellate courts to kind of clear up some of these issues. And ultimately, this case could be very valuable to the fabric of Texas self-defense law.
But taken on its face, we're interested to see what you folks have to say. Is this one of those things where we think it's all right for thieves to claim self-defense? Do we think this is justified, not justified? We want to hear from you, but we hope you enjoyed this discussion. If you did, consider subscribing, hitting that like button, and help us fight the anti-2A algorithm by sharing this video. And until next time, we're the Armed Attorneys.